Today, we're diving into a really big shift happening in Uganda's legal world. Back in 2026, the country decided to roll out some brand new rules aimed at changing how everyday civil disputes get resolved. But why? What was the problem they were trying to fix? Well, it all starts with this number, 167,000. That's how many cases are currently stuck, just waiting, in Uganda's court system. It is a massive figure, and it points to a huge, huge challenge for anyone hoping for timely justice. And this isn't some new problem that just popped up overnight. Just look at this chart. You can see how much pressure the system's been under. A decade ago, back in 2015, the caseload was already high at around 114,000. Fast forward to 2025, and it just ballooned to over 167,000. Now, behind every single one of those numbers, there are real people, real businesses, just waiting, sometimes for years. And when a case is pending, it means your life is kind of put on hold. Assets might be frozen. You can't move forward. It's the textbook definition of justice delayed being justice denied. So that brings us to the big question, the one at the very heart of this whole reform. Is fighting it out in a traditional courtroom the only way? Or, just maybe, is there a better, faster path forward? Uganda's answer to that question is a pretty bold one. They're making a huge investment in an alternative path, mediation. And they've made it official with the new Judicature rules of 2026. This isn't just some small tweak to the system. It's a fundamental rethinking of how to deliver civil justice. So what exactly is court-annexed mediation? Let's break it down real simple. Think of it as a guided negotiation. You've got a neutral professional, the mediator, who helps both sides talk things through. But here's the key. The parties themselves come up with the solution. And if they agree, the court stamps it, and it becomes as powerful and binding as any judge's final ruling. And, this isn't just about being more efficient or clearing cases faster. As Uganda's Chief Justice put it, the real vision here is to create a more people-centered system. The idea is to hand some of the control back to the citizens, to let them have a real say in the outcome of their own disputes. Okay, so that's the big idea. But how do these new rules actually work on the ground? And what makes them so different from the way things were done before under the old 2013 system? Let's get into the nitty-gritty. This table right here shows a huge philosophical shift. It's night and day, really. Before, mediation was mandatory. You had to do it. Now it's totally voluntary. Before, you had to pay the mediator out of your own pocket. Now, the state picks up the tab. And maybe the biggest change of all, before, the court picked your mediator for you. Now, you and the other party get to choose your own. That is a massive transfer of power. So, what's the big takeaway from all that? Well, this whole new system is really built on three simple but totally powerful ideas. Number one, it's your choice. Number two, it's free. And number three, it's designed to be fast. And just how fast is fast? Well, the entire process is built to be wrapped up in just 60 days. As you can see, it's a clear roadmap. It all starts with both sides agreeing to try it. Then they pick a mediator, and the confidential talks begin. If they manage to strike a deal, it gets written up, and boom, it becomes a binding court order. It's a clear, predictable timeline, which is something the old system just couldn't offer. So you might be wondering, how does this new Ugandan model compare to what its neighbors are doing? Is this a pretty common approach across the region, or is Uganda really charting its own course here? And this table really shows you what makes Uganda's systems stand out. It's pretty fascinating, actually. If you look at Kenya or South Africa's Gauteng province, they tend to make mediation mandatory. And in all three of these other countries, the people involved have to pay the mediator themselves. Uganda's the only one in this group that combines a system that's completely voluntary with state funding. It's a really distinct experiment in how to provide access to justice. Now, when you introduce a change this big, it's going to have a ripple effect across the entire legal system. So what does this actually mean in practical terms? For the people, the legal professionals, and the courts themselves?
For regular people and for businesses, the benefits are pretty straightforward. You get a faster way to solve your problems. It doesn't cost you anything for the mediator. You get way more say in what the final agreement looks like, and that agreement is just as solid and legally enforceable as a judge's verdict. For lawyers, this really requires a different mindset. You go from being a courtroom warrior to more of a collaborative advisor, guiding your client through a negotiation. It also opens up this whole new career path for professional mediators. And for the courts,
Well, the big hope is that this acts like a pressure release valve. It could free them up to focus on those really complex cases that absolutely need a full trial. And the potential for impact here is just enormous. If you look at the data from 2025, mediation was already solving over 5,000 cases a year. But when you've got a backlog of nearly 50,000 cases, there is so much room to grow. I mean, if this new, easier, free system just doubles or even triples the number of people who use it, it could make a serious dent in that backlog. But let's be real. Writing new rules is the easy part. Changing a culture, especially one that's been around for a long, long time, that's a whole different challenge. A new rulebook is a great start, but it's just that, a start. At the end of the day, it all comes down to execution. Are the lawyers and judges actually going to buy into this new way of doing things? Is the government going to put up the money needed to pay for it all? Are there even enough high-quality, trained mediators out there? And can the court's own technology even keep up with tracking all this? These are the really tough questions that are going to decide if this whole thing works. And that leaves us with the ultimate question, doesn't it? Uganda has launched this really bold experiment. It's a bet that a system built on personal choice and public funding can actually solve this deep, decades-old problem of delayed justice. The blueprint looks great, but whether it can truly deliver on that promise for everyone, well, that's the story we'll all be watching in the years ahead.